the provision of actual medical services. It had
But that person is an employee of Shands.
That person is an employee of Shands. But as we argue in our brief and based on cases that are cited, except there are others, of course, the right to approve the hiring or retention of an individual is evidence of a right of control. And if we were obliged to show only a right of control over medical services, since according to MedTrans, and the record supports them on this, although the record may be disputed, the medical director, through protocols, not actual hands-on supervision of the medical crews, is the ultimate authority. But if someone can, as in the court's case in Gradia not too long ago in 2022, the right of hiring is evidence of a right of control. Further down the list, there is a right that they dispute this, but the evidence is very favorable to us on this question. There is a right to provide so-called CRM training to the medical crews, which is mandatory in the record. There's no dispute about that. And in the light most favorable to us, because the documents say so, that training includes not only medical errors, it includes medical management issues, it includes adverse case studies. And they tell the court that this is all part of what the FAA requires, but as we've cited the relevant provisions from the federal regulations, that's just not the case. They say clinical training effectively is not clinical training, but the contract is very clear that they have a right to require clinical, and that is medical, obviously, clinical and didactic training of the medical crews. The issue of the property, which is owned, the most important property, we would argue, certainly in the light most favorable to the plaintiff, the helicopter in this case. It was a series of testimony, and I urge the court to consider, because it's set out pretty succinctly in the record, pages 2218 to 2221 and 2405 and 06 of the record on appeal. This company, this defendant, changed the configurations of helicopters that were in use over time in the Shands Care program. Shands personnel objected to them doing that, and one of the reasons that they did so was because it would make, and if you can envision this, these medical crews have to actually perform services in a seated position or a semi-seated position in the instance of providing chest compressions. The Shands personnel objected to that, and the objections were overruled, even though the specific concerns that Shands personnel had would be that it would make the performance of medical services more difficult, including the performance of CPR. It's very clear in the record. They sort of pour cold water on that and say, well, we're just doing what a helicopter owner would do. But the point is, in trying to decide whether there's any voice, if we were required to be focused only on the issues of medical care, they had an absolute right through their ownership of the most important piece of equipment in the case to do so. With respect to other medical issues in the case, there is evidence that there is a right of MedTrans. It's in the contract. They have the right, and this is really a question of contract interpretation. Neither side has argued, interestingly, that there's any ambiguity here. Our point is that as in Gradia, the contract cuts both ways. If you take a look at their right to bill for the medical services in the case, they call that transport services. But in the light most favorable to us, transport services are medical services. And I just urge the court to consider this very brief example of that. I believe it's at page 2085 and 2086 of the record.
So are those items billed separately? Is the helicopter ride
right,
and then the medical care on the helicopter,
right,
those billed separately, or are those all billed together?
No, that's the point. If you look at 2085 of the record, in their contract, we're not accusing them of committing Medicaid fraud. And by the way, the Medicaid program resolved this bill. That's at 2086 of the record. But in their contract, they say, we only bill for transport services. Take a look at what they bill for at 2085. It's a $43,000 bill. What did they bill for? They billed for the administration of IV drugs, giving a specific CPT code, and they billed for the administration of chest compression and CPR, the very thing that got them sued for in this case. And they're going to tell you when I sit down that the only thing that they do is transport services. But the contract, in the light most favorable to us, and what they actually charge the state's Medicaid program, suggests it is actually something much more than that. But I think the other point, getting back to where I started, Judge Lewis, they have made an attempt in this case, and they persuaded the trial court of it, is that you could make a very neat division between medical services and transport-related services. And the record does not support them, certainly not in the light most favorable to us. There's a necessary overlap between doing such things as charting, over which Medtrans has, according to the contract, a right of control. It's required that the medical crews use their billing services, that they do the work with their supplied computers on base where they have a sole right of control. And there is just a list of things that it is very difficult in a summary judgment posture to say, well, this is all transportation related and this is all medical related. But getting back to where I started, Judge Lewis, it's our position, as you know, that if you take a look at this court's decisions, and I'm referring specifically to Nasworth, to DeBolt, and also, in fairness to us, the Del Pilar case, those are all cases where the things that this court focused on in deciding there were disputed issues of material fact and reversing summary judgments had nothing to do with the things that put the parties in court. In DeBolt, for example, the court talked about a number of conditions that were imposed on by HRS on a so-called detention home. And if the court's forgotten, that's a home where HRS puts delinquent children for their supervision. The things had nothing to do with what happened in the case. And in the case, there was an unsecured rifle that ended up being operated by one of the couple's children and shot this kid. The conditions that are imposed on the couples relate to things like religious indoctrination, can't do that, can't take the child out of the home, but nothing relating to physical perils like that. It's similar in the Nasworth case, where the issue in the case was negligent driving, and the relationship involved was a relationship between a shopping mall owner and a management firm. Nothing in the contract that this court relied on had anything to do with driving. Nothing whatsoever. The Del Pilar case, which both sides have cited at various points in the litigation, is a little bit closer. In that case, it's an accident involving one of the delivery services companies. I think it's DHL. The things that the court focused on in looking at the contract between the independent contractor, so-called, and DHL related to the packaging of products, the management of fleets, but not with respect to the maintenance of vehicles per se or driving, and also with respect to the way in which the packages were set for delivery. It was an auto accident case where a DHL van owned by a purported independent contractor struck and hit the plaintiff. And this contract said nothing about driving, and yet this court, looking at the similar elements and indicia of control, decided that that was sufficient to reverse a summary judgment. A very similar case is the Carlson case. I cited that. It's basically a duplicate, although the legal issues are different, to Del Pilar, and it relies on Del Pilar, but it applies the federal summary judgment standard and also applies Florida law. The point is that even though there is evidence in this case of an overlap, not only an overlap between medical services and transport services, there was no requirement that there be such an overlap. And there further, in this case, as I just mentioned in responding to your question, Judge Lewis, is direct rights of control over the delivery of medical services. There's no other way to read that bill in the contract. And they say, well, everything that says transport is transport, and there's such a neat dividing line that the court correctly entered summary judgment. But what the court actually did was say, the trial court said, well, the plaintiff raised some indicia of control, but they're not important. Didn't say what they were or why they don't get counted, but just said that they weren't important. And that's a primary fault for a trial court in this setting, in the posture of a summary judgment, to weigh the evidence as this trial court did and decide what's important and what's not.
Counsel, you cited this court's opinion in Grittier versus Baptist Hospital several times in your brief. How does this court's opinion in Baptist Hospital, support your argument on the merits?
The main focus on that, and Gradia did not actually break new law in this regard, the main point of that is the court very clearly stated, we've got this complicated contract. It allocates certain rights of control and supervision to both sides, that is to say between the emergency room firm that was sued for its emergency room doctor and the hospital, but that it cut both ways. I mean, that's the point. It didn't really break new law. It is a very favorable expression to us. I would urge the court to consider, there's a long statement at the end of Villazon and Justice Lewis opinions about how the way that modern medicine is practiced, and I think it's applicable here, the idea that there's just everybody out there who performs medical services as an independent contractor, doing their own thing, not subject to the influences of anybody else. In the world in which we live today, where there are complicated relationships between providers, hospitals, in this case an ambulance firm, that just doesn't hold up where there is a contract that is as complicated and allocates so many rights. If you think about it this way.
Counsel, you are into your rebuttal time.
I'll take a seat in one moment. Thank you, Your Honor. If you think about it this way, the mission in this case took an hour and 40 minutes. An hour and 40 minutes to complete. For the entirety of the rest of the 24-hour shift of this medical crew, they were on the MedTrans base, and the contract clearly states that during 100% of that time, they were subject to a right of so-called sole control and supervision and control, and those are the terms contained in the contract. And thank you, Your Honor. I'd like to save the rest of my time.
But I got a question about that. I mean, does that just mean while they're on the base around the helicopter, they have to follow all the helicopter rules? I mean, that doesn't seem like medical care to me. I mean, if you go down to the airport and try to get on the Delta flight, the captain of that flight has the right to basically say you don't get on for any reason he wants.
I think you have to look at, that's a different issue. That's when they actually land and pick up a patient. I think that's a little bit different. But what I was referring to, Judge Roberts, is the list of enumerated duties that are contained in the contract that the medical crew has to perform, not while they're out in the field, not while the pilot is telling them what they can and what patients they can and can't receive, which I think is an evidence of a right of control. I'm talking about that 22-plus hour period in this case where they're on base and the enumerated duties that they're required to perform at the direction of MedTrans, which include medical training. There's no other way to slice it. It includes cleaning a helicopter. There's nothing, I mean, you could argue it's medical. You could argue it's solely medically related, I suppose, or argue that it's solely transportation related. But there are all of these things, including all of the training that they have to submit to. And this is in the nature, and I think the reason it's like this, if I can just leave this, is that this organization, it has to sort of be run like a military organization, like a military operation. And the ultimate authority has to be vested with the party that's operating the helicopters. There has to be certain rights of control, and it makes sense. But in this particular instance, you can't have all these rights and secure and reserve all these rights for yourself and then say, hey, I'm an independent contractor. And that's one of the lessons of Gradia as well.
And I trust the presiding judge will give you a few more minutes since I used up all your rebuttal time.
I thought the clock looked like it was stopped. Now it's down to, I don't know what happened. But anyway, I appreciate that. Thank you, Your Honor.
Thank you, counsel. You may approach, counsel. We will add additional 2 minutes to your time, counsel, and we'll add additional 2 minutes to counsel for the appellant's rebuttal time.
Oh, wait. Okay. So sorry. Thank you, Your Honor. May it please the court, we're here today on behalf of MedTrans asking this court to affirm the trial court's order entering summary judgment in its favor. The appellant's argument ignores the totality of the master agreement between Shands and MedTrans, and it also ignores the undisputed record evidence in this case. Very briefly, I want to address the arguments that the medical crew is required to perform all these duties for MedTrans. If you look at the medical service agreement, there is a provision talking about what the duties of the medical crew are. But first of all, that addendum is for medical crew services. Underneath the contract, Section 7, the Shands provides the medical crew services, the program director, the medical director, and the contract expressly states that all the medical care has to be rendered pursuant to the direction and protocols created by Shands and implemented by the medical director. The description of duties doesn't say that they are required by MedTrans. For example, some of the medical crew duties include attending training offered by the medical director. There is a reference to didactic and clinical training that the appellant has referenced. But if you look in the subsection above, the contract is unambiguous that Shands is responsible for hiring, licensing, training, scheduling the medical crew. And that's because...
As a follow-up to the appellant's argument, why is Medtrans control over the transportation-related aspects of the medical crew's activities irrelevant to deciding the issue?
That's because you have to look at what the contractual undertaking is. As the court said in Harper, the 3rd DCA noted that in any independent contractor, employer, agency, there's going to be some control between the parties. The issue is, does the principal have the right to control the means and manners of that contractor's contractual undertaking? So what is it that the Shands medical crew has contracted to provide? And that is unambiguously medical services. They are provided by Shands because Shands has retained control over the medical care in this program.
Counsel, I'm sorry. What if the alleged negligence in this case stemmed from an aviation-related issue? Say, for example, the medical crew did not properly secure the patient and the patient was injured as a result. Would there be an agency showing in that case?
Your Honor, I think it would still turn on whether or not there is evidence of Shands' contractual undertaking being transport services. Under this agreement, there's an acknowledgement that occasionally the crew members are going to be engaged in transport-related services separate and apart from medical care. For example, the record evidence was that before and after each flight, the entire crew takes a circle around the helicopter to look for equipment that's out of place. They look for anything off with the helicopter.
But the point of my question is, it seems to be a very fine line, if one at all, between, I guess, the distinction between the provision of medical services in flight and the provision of aviation services in flight, and then that line could be blurred in my example, I think. So going back to my example, why wouldn't there be an agency relationship there if the injury stemmed from the failure to abide by one of the aviation-related rules set by the pilot?
Yes, Your Honor. I think there may be liability for Medtrans, maybe a direct negligence claim, but the issue would be whether or not what that medical crew member did it relate to the scope of their contractual undertaking, and is there evidence of control over the contractual undertaking? So in that context, I would still say that under this agreement, there would not be liable on an agency basis, possibly a direct negligence for failing to train or failing to supervise, but not agency just based on a right of control. I think we can also look to the argument that the control doesn't have to relate to the negligence at issue is not supported by the case law. In medical malpractice cases, the analysis of control hinges on whether or not the principal has the right to control the manner and means in which the agent or the physician or healthcare provider is rendering the medical care. If you look at Stoll, Villazon, and Gradia, which I think I'll talk about in a minute, in all of those cases, the analysis was, is the principal directing the medical treatment and care? In Theodore versus Graham, that was a sovereign immunity case based on agency. And the court noted that the evidence of control in that case related to administrative tasks. It did not relate to the provision of medical care. And in denying agency, the court noted, this is a case involving the contractual undertaking of providing medical care. So evidence of control related to administrative paperwork is not sufficient to create evidence of a right of control. If we look at Gradia, I think Gradia is a great example of what evidence is required to create a disputed issue effect on agency. In Gradia, the court noted that if the contract can go both ways, that can create an issue effect. But the court also analyzed the entire record evidence in Gradia. Also in Gradia, the agreement was expressly contradictory. In Gradia, you had contracted emergency department physicians contracted with Baptist Hospital. And the contract said they were independent contractors, but if you looked at the language of the agreement, it expressly stated that the hospital had authority over the emergency room care. In Gradia, the contract said that they had the right to control emergency services and make sure they were provided in strict accordance with currently approved methods and practices, and that ultimately the hospital retained supervision and control. In this case, the appellant is trying to create ambiguity by saying that transport services includes medical care. That is not expressly stated in the agreement, and in fact, the agreement throughout makes it clear that these are two realms of responsibility. So in Grada, you have an agreement that expressly says that the hospital has the ultimate right to control the medical care. In addition, in Grada, when you looked at the evidence, the hospital had created medical protocols that it required the physicians to follow, that there was a medical protocol directly related to the care at issue, and in fact, the physician testified that he had looked at that protocol when he was treating the plaintiff related to the care alleged to be negligent. The court...
So sorry. Mr. Sales had pointed out that your client had in fact billed for medical services. Do you agree with that? And if you do, why do you think that is not relevant to the agency determination?
Your Honor, billing is the one item that's expressly enumerated in the transport services. It basically says that MedTrans would be responsible for the billing. And so I think that contractually they have agreed to provide this administrative function, but there is no evidence in the contract or in the record that they have any say over the medical care that's being rendered. There is no one at MedTrans that can direct the medical care. There are no protocols. All of the witnesses testified that no one at MedTrans supervises the Shands medical director, the Shands program director, or the chief flight nurse.
But they have approval over hiring the medical director, and that's some amount of control. If I get to say whether I hire you, I have some amount of control.
Your Honor, that's a slight misconstruction of what the contract says. The contract says that the medical director will be Dr. Maurer, who was already a Shands employee in that position, and that if they had to replace Dr. Maurer, they would do so with somebody with that was reasonably acceptable to MedTrans. This is not a right to approve the hiring of every nurse and paramedic. It merely gives MedTrans the right to say, we don't really like this guy, maybe somebody else, but there's no indication that it gives MedTrans the right to tell that medical director how to do his job, how to oversee the medical care that's being rendered.
Well then, counsel, please explain why Section 7.2 of the Medical Crew Services Addendum, titled Supervision and Control, does not support appellant's agency argument.
Which section, Your Honor?
Section 7.2 of the Medical Crew Services Addendum.
Yes, that is because that section relates to the instances in which they are assisting with transport services, not medical services. So, for example, in the times we talked about where they're inspecting the helicopter for safety issues, or if they're taking FAA-mandated training, the pilot is in charge in those contexts. He has to be from a safety standpoint. But he's in charge as it relates to aviation services. The pilot is not in charge as it relates to the medical care that's rendered. And that's the analysis, is what is the contractual undertaking? The contractual undertaking is the provision of medical care. It's not transport services. But there is an acknowledgement in the contract in several places that there may be some times when the medical crew in the base is going to have to help the pilot out because the pilot is ultimately responsible for keeping everyone safe in the helicopter. I also want to point out that as it relates to our alternative sovereign immunity argument, that appellants have essentially kind of argued themselves into a corner. You just heard Mr. Sells argue that transport services includes medical services. And if that's true, we disagree with that construction. We think the agreement is pretty clearly delineates two spheres of responsibility. Shands historically ran an air ambulance program for 40 years before MedTrans was ever on the scene. Shands wanted to expand its reach in the community, so Shands retained MedTrans to provide helicopters and pilots, while it specifically says in the preliminary statements that Shands intended to retain control over the medical services and the clinical services of the program. So they bring MedTrans in for the aviation services, and MedTrans retains control over the medical services.
Counsel, your sovereign immunity argument relates to the caps on damages and not as to absolute immunity on the negligence claims.
That is correct, Your Honor, but even as it relates to the limited application of sovereign immunity, a potentially sovereignly immune defendant is entitled to a determination of sovereign immunity as early as is possible based on the record. That is still a ruling that they are a sovereign entitled to immunity. It is just subject to the limitations set forth in the cap. But because the appellants have argued that transport services includes medical services, then that means they're saying that MedTrans contracted with Shands to provide medical services as part of transport services. If that's true, it's undisputed in this records that Shands has an ultimate right to control the medical care. So Shands has an ultimate right to control part of the contractual undertaking of MedTrans if you buy the argument that transport services includes medical care.
Did the trial court reach your sovereign immunity argument?
Your Honor, because the trial court found that there was no agency relationship, the judge did not. It was essentially kind of moot because there's no agency relationship, so she did not rule on sovereign immunity. So we have raised that as essentially a tipsy coachman argument that it would support affirmation of the entry of summary judgment on different grounds that were raised in our motion for summary judgment. And if there is an agency relationship here, it is clear that Shands is the principal. MedTrans was retained in order to perform services for Shands. The helicopters have Shands logos. All of the mechanic and the pilot wears a uniform with Shands logo. Shands controls the dispatch. Shands controls the program director, the medical director, all of those things. And so on a day-to-day basis, Shands is telling the pilot where to go, who to pick up, where to take them. The medical crew, who are all Shands employees that we do not control, make a determination whether it's medically necessary to transport the patient. All of that's within Shands' control. So if transport services are not separate and distinct from medical services, then the only the only conclusion is that MedTrans is actually an agent of Shands entitled to the protections of sovereign immunity. But we believe that the agreement is clear. And I wanted to talk a little bit about a couple of the other provisions about the training. The agreement in 4.3, talking about the medical crew services, does not say that MedTrans is responsible for any clinical training. In fact, in 4.1 of the medical services addendum, it clearly states that the hospital shall be responsible for training as it relates to medical. Now, the FAA requires crew resource management training. That part of it is undisputed. The appellants point out that there are some slides in a training that were unauthenticated. We don't know if they were actually used for this particular operation. MedTrans has operations elsewhere where sometimes it does control the medical care. But that is not the agreement that it has here. So we don't know where this training came from. But regardless, it's an aviation safety requirement that was put in place by the FAA. And there's case law that says if the government is requiring, mandating something, that is not necessarily evidence of control. There is no evidence of control in this record over the rendering of medical care. The pilot can't supervise medical care, neither can the mechanic, and there's no evidence that anyone else at MedTrans retains a right to control the provision of medical services.
Counsel, I believe you addressed my question beforehand, but let me just follow up again with my initial question. Why is MedTrans' control over the transportation-related aspects of the medical crew's activities irrelevant to deciding the issue of agency?
One, Your Honor, it's our position that the tangential assistance with transport services does not relate to their primary contractual undertaking, which is the provision of medical services. It is just a necessary incident of the relationship that sometimes they will be assisting the pilot and the mechanic as it relates to transport services. In addition, a common principle of tort is that the negligence has to relate to the scope of the agency. So to the extent the agency between MedTrans and the crew is that they're going to help with the helicopter, the negligence here relates to medical care. And that's why we're talking about whether or not there is a right to control the medical services that were rendered. Because if it was that, they can help with transport services and those are separate and apart from the medical care, that's outside the scope of the agency with MedTrans. MedTrans has no control over the provision of medical services, and that's why we ask this court to affirm the trial court's order.
Thank you, Counsel.
Thank you.
I would like to spend 5 seconds trying to dispose of the issue of authenticity. This is the sworn testimony of the president of the defendant, Medtrans, referring to the same training materials that are in our appendix and the counsel was just discussing. Question: this is the Medtrans CRM program to Shands. Answer: correct. The president of the company said these were Medtrans materials. We spent more energy on that in the brief than just that, but that ought to put that issue to bed. I want to respond next to counsel's suggestion that there has to be a relationship. In the old days, some of your colleagues used to say, what's your best case? So, Grotti is not our best case for reasons that have been identified. But the law is very clear that there does not have to be a relationship between the particular detail. Otherwise, there would never be a hospital found to be vicariously liable for the actions of a so-called independent contractor.
But would you agree that Grotti is distinguishable on the facts?
No, I think they're the same. I think the key point of Grotti is if the contract cuts both ways, and by the way, neither side says it's ambiguous. It cuts both ways unambiguously, but this is the case that I was referring to, Your Honor. This is Garcia versus Tario, 380 Southern 2nd, 1068. We've been citing this case for decades. That is a case where the anesthesiologist's actions were charged to the defendant hospital in the case. This is from the court's opinion affirming a denial of a directed verdict, okay? Rather, Dr. Garcia had an agreement with the hospital guaranteeing him at least 50% of the work of the hospital, so he had a locked-in deal. He did not work anywhere else. Sounds familiar to this case. The hospital supplied him with equipment necessary for his work. The helicopter is not a small item in this case. The administrator of the hospital did not recall using an outside anesthesiologist. That was it. And I agree that's not a great record for the plaintiff in the case, but the point is that sort of looks like an agency relationship. And here, and in this case, there are so many things that Medtrans, and for reasons I believe that I've suggested, because it's running what is essentially, and all these people are former military, by the way, so they all speak the same language, and they get it. They're on duty, they're on a base, yes sir, no sir, yes ma'am, no ma'am, and that's the way that it works. But with more specific detail on that, and I'm ready to spend a minute talking about the sovereign immunity issue, we are not telling the court what the contract means. We're telling the court what the contract says. This is at 2996, sole control over transport services, paragraph 8.2. This is at 3016. The medical crew will be available for activities of MTC bases such as transport services. And then it gives a list that's 20 or 30 lines long of the things that they have sole control over. And as I was trying to say before, overwhelmingly, that's the majority of the time of these folks doing this work. Paragraph 7.2, I think you referenced that.
So I wonder if your military analogy breaks down, because if I'm an infantry lieutenant and the warrant officer that's flying my helicopter on the ground, he has to salute me and call me sir, and I could assign him some extra duties, but when he's flying that helicopter, I can tell him where I want to go, but I can't tell him at all how to fly the helicopter or what route to take.
Right, but I think
so he has flying authority, but on the ground, the fact that there's overlapping when these people are on the ground doesn't mean there's overlapping when these people are in the air.
Well, but there is overlapping when they're in the air, because the nature of an ambulance service, particularly when in flight, and you get from the record, the testimony, you get a feel for this. The pilot ultimately gets to say the way things happen. Get in your seat, buckle. I mean, there's a lot to it.
Yeah, but
I agree with you.
Not how to treat the patient.
I agree with you, but there are, I don't want to go back through that because I'm almost out of my time. But on 7, it does break down to that extent, Your Honor. 7.2, it says supervision and control includes but is not limited to training medical crew members on the day-to-day duties specific to Medtrans support services, overseeing the day-to-day activities of the medical crew pertaining to transport services, and controlling the Medtrans base site from which the medical crew performs transport services. The point is is that it's not
Counsel,
only
your time-
overlapping.
Your time has expired, but I will allow you to wrap up.
I would just like to say, with respect, just the cases that are cited on this sovereign immunity issue, they require that the private corporation be a virtual alter ego of the public entity or agency. That just doesn't exist in this case. The evidence is conflicting on both sides. This is a case where summary judgment might be available to us on the sovereign immunity issue, but we didn't get to that point. So I just urge the court to read the cases, particularly the Supreme Court's cases on that. And the court should reverse for the reasons already given. Thank you so much.
Thank you, counsels, for your respective oral arguments this afternoon. This concludes our oral arguments for this afternoon. We stand adjourned.
All rise.
My least favorite part is putting all these papers back together, which I'm not going to do. You did a very nice job.
Oh, thank you, you did too, thank you.
You just want-
Have a safe drive back?
I'm
Flight?
flying to New Hampshire
Oh, we'll have a safe flight.
through Charlotte or somewhere to Washington.
That's at least a.
My mother had a
route.
stroke recently, so I'm trying to hang out there. But no, she's doing pretty good.
doing better?
She's doing better, yeah. It is very nice.
Got you,